Good morning, everyone. And respect everyone's time and wanting to participate in this important topic. I'd like to introduce myself, Vicki Talley, Med Executive Director, and thank you all very, very much for signing up for our very, very first webinar, New COVID-19 Evictions and Rent Subsidy Regulations. It's a very timely topic and one that everybody is very anxious to learn everything they can about it quickly because of all the deadlines coming up. I want to very first thank MHET advisory board member, Dan Rutterow, for volunteering to facilitate this webinar. MHET has never done a webinar before, and Dan has done these and has the expertise and staff to be able to put this on, and we can't tell him how very much we appreciate being able to have him co-sponsor this and help us with our first webinar, if you will, and we'll move forward, hopefully, as the year goes on, getting much more proficient in this ability. Our goal this year actually is to schedule regular monthly meetings, Zoom meetings or webinars on the fourth Wednesday, which is our traditional meeting day for our mobile home park owner forums. In 2020, I think we kept thinking, oh, it's going to be over. We're going to be able to meet. We'll be able to get together. And it never happened. This year, we're going to just plan on making sure we get together, making sure we have outreach, not only through our webinars and Zoom meetings on a regular basis, but also on our email communication. So we really appreciate your patience and understanding with that. It's been a little bit of a challenge, lots of things going on. I wanted to also take this opportunity to really thank past President Liam Miller, 2021 President Aveen Cirillo, and all the members of our board of directors for really their leadership. It's incredible. We've continued to meet, of course, on a regular basis, on a monthly basis, managing your association. Last year was a big election year, and this year all of the follow-up and what's the challenges that are going to follow with the COVID and everything else. So I want to thank also not just the board members, but also our sponsors and our service and industry members. Our annual sponsors are very important to our membership and supporting our organization. We appreciate all of our members calling our service and industry and our sponsor members first. A few words about the program today. We've scheduled it to go for an hour and a half. We don't think it's going to go that long, but we want to be prepared to answer all questions that come up. And I want to, Dan will be doing his presentation aided by a PowerPoint, which we will make available to everyone after the program, along with the video and also some forms that are going to be, that you will need to be serving as you will learn from Dan. We will have a Q&A at the end of Dan's presentation, and we facilitated so you can ask those questions online. So if you look at the screenshot here, it's got, you see down at the bottom of your screen, you'll see a Q&A. If you click on that, you can type in your question. There's also an icon next to questions that if you like a question that's been asked and you want to ask the same question, just click on the icon that votes to move. I'm using that terminology loosely, but you'll get the idea when you see the icon that you would you would vote for that question to move up. You'd have two people asking the same question in essence. So I think it's pretty intuitive, and we're going to facilitate the program that way, and we'll moderate questions at the end. I think that we've covered pretty much all of it, and you're here and participating because you want to hear this important program and the information. Without further ado, I would like to introduce Dan to do the presentation. Thank you, Dan.
Thank you, Vicki. I really appreciate this opportunity. Thank you for inviting me today. I appreciate it. We'll get over to the, we'll put up our PowerPoint first. Hi, everybody. Happy Friday. Welcome. We'll get our PowerPoint in front of you so that we can, there we go. And then we'll do this. There we go. Welcome, everybody. A lot's going on with the new COVID moratorium law that was that was just recently passed. So let me go through this and try to explain something that's very complicated. I think the copy of my new law is about 31 pages long. So we're going to try to organize and condense and summarize for you the law in a way that I think is pretty logical. So you're all familiar with the COVID moratorium law last year. That was called the COVID-19 Tenant Relief Act of 2020. And many of you are in court with maybe your attorney and judges, and they keep saying Assembly Bill 3088. And Assembly Bill 3088 was what enacted last year's COVID law. Now we have Senate Bill 91 that was signed into law on January 29th. And now they're just calling today's new moratorium law the COVID-19 Tenant Relief Act. Very similar, as we'll get into. It basically extends the time period from January 31st to June. But a big component this time, which is different, is that the federal government has funded a new California emergency rental assistance program. So weaved into this law is information about the rental assistance program, which is now available to tenants as well as landlords. So first off, I know a lot of people have some questions. We here at Rotorua Law Group, we do regular landlord tenant evictions. We do, of course, mobile home park evictions, and we do other types of evictions like RVs. So to kind of start at the beginning, this new COVID law, what does it apply to and what does it not apply to? And very specifically, what the law did was it says that it does apply and does amend the mobile home residency law in terms of non-payment of rent. So if you have a non-payment of rent eviction in a mobile home park, this new COVID law applies. The law also says it applies to normal landlord-tenant situations, and you and your park communities may have such a situation when you're actually renting a park-owned home and the space. In those situations, as you know, the regular landlord-tenant rules will apply. And so this new COVID law will apply to those non-payment of rent cases. And it also references that it applies to a neglect or failure to perform the lease conditions in those types of evictions. So on the other hand, people want to know, well, what does it not apply to? How may I, if I want to, how can I evict people perhaps for other reasons? I think that there's a strong consensus looking at the new law by our industry attorneys in our industry that, like the old COVID law, the new COVID law does not apply to other types of evictions brought under the MRL, such as if you have a tenant in your mobile home park who is really causing problems in your park, and you think that that tenant could qualify to be someone that you've tried to get them to behave, but they're really causing a substantial annoyance to other people in the park. As you know, substantial annoyance is one of the ways you can evict someone, and you can continue to do so under the new COVID law. As you're also probably very familiar with, you have another alternative that park owners can evict someone for breaching or violating one of the park rules and regulations. That also appears to be something that's unaffected by the COVID laws. So you can go forward with your MRL substantial annoyance evictions, and you can go forward with your rule violation evictions. Also, for those of you who, some of our members have mobile home parks in which inside the mobile home park, you have a separately designated area for RV residents. And sometimes the RV code applies. I think at this point, because the RV code is not even mentioned in the new COVID law, that the lawyers are considering the fact that are taking the position that the new COVID law does not apply to your RB evictions, your RB non-payment of rent cases. There is an exception, and I'll get into that in a moment. So you'll want to always discuss these issues with your lawyer. I know that always sounds like a standard disclaimer that all of us lawyers say when we do these presentations. We're all licensed lawyers. And what I do want to reiterate, especially with this new law, is you should never rely on what I'm telling you. You shouldn't rely on this PowerPoint. By all means, get a copy of it from the MHET. But these are some very sort of complicated issues that come up that you should get with your park lawyer and review. And one of the issues that we're seeing in our office is we're seeing a little bit of an issue with evictions where the law said that we can evict people without cause. For instance, there's many examples, but under the RB code, if a person's been staying with you less than 9 months, you can evict them with a 30-day notice without cause. That seems to be a hiccup that the new COVID law says, ironically, says that you have to have cause to evict someone. And some of our legal aid societies, some of our legal aid attorneys who represent the tenants in our eviction proceedings are actually making motions right now, which we are opposing in court in front of the judge. And what legal aid is saying is that no cause is something that looks like you can't go forward with, given the way that the new COVID law is worded. So that's something you're going to want to take a look at closely, because it's always been traditional in our industry that sometimes a park owner will want to go with the no cause route of evicting someone if that makes more logical sense under the law, if it's a more efficient process. If it seems more efficient than a more cumbersome way of doing eviction another way. But now we sort of have an issue with these no causes. And I think I have one demur and maybe one motion for summary judgment being filed against our park owners for these no cause evictions. So take a look at that with your attorney very carefully. So I know this is a lot of text, and I know the way I wrote this with the bullet points may just sort of give you a headache, but I just wanted to put the dates up there because, like the old COVID law, as well as today's COVID law, what we're talking about is we're talking about the situation where you have a tenant who fails to pay rent. And we're talking about what type of eviction notices you have to give that person if they default in the rent during certain time periods. So as you all remember, there was, generally speaking, under the old law, there was this huge covered time period between March 1 of 2020 and January 31st, 2021. So now, before that expired on January 29th, the governor signed into law the new law, which basically extended that January 31st date all the way to June 30th. And what we're talking about, again, like I said, is the whole point of this is to look at the period of time, and we're in the middle of this period of time. So any rent defaults you have today all the way through June 30th, we're talking about what type of eviction notices you have to give. And it's for what they call under the law, they call it serving an eviction notice for unpaid COVID rental debt, which is this definition here at the bottom. And I noticed in some other webinars I've attended, a lot of people have questions about utilities, maybe other charges on the rent statement. The way this is worded, it says that if you're trying to evict someone for unpaid COVID rental debt, you have to give the requisite eviction notices. And they define rental debt as being not only unpaid rent, but unpaid financial obligations. So most lawyers are going to say your unpaid financial obligations are your utilities and perhaps something else that you give to the tenant every month on their rent statement, some other charges. So if they're, if they're defaulting just on the utilities or part of the rent, that's all covered. That's all considered rental debt. And when they default on this type of rental debt, then you've got to go through and give them the requisite eviction notices. So like last time, as I think all of you are familiar, just like last time, under the new law, if you're going to try to evict someone for non-payment of rent, you need to give them no longer a 3-day notice. You have to give them a 15-day notice. And as I know we've joked last year, it was easy around the water cooler to say 3360, 3360, and I and my attorneys are kind of having a difficult time saying 1560. Takes a little bit longer to say that, but around our office doing mobile home park evictions, that's what we have today. So the wording has changed. I know it's like, are you kidding me? Now the 15-day notice has changed. Well, it's changed because in the new 15-day notice, there's a little bit of slight different wording, not only about their rights to submit a COVID declaration, but the new 15-day notice language now also advises people of the availability of rental assistance. So there's a lot to the new worded 15-day notice. So you'll want to make sure if you're going to serve a 15-day notice starting, today or yesterday or tomorrow, that you've got the new language that you need in your 15-day notice. Like last time, what you're doing is that you're handing the tenant a 15-day notice, and then accompanying that 15-day notice is a COVID declaration. And so as you're familiar with, that has not changed. You're serving the 15-day notice that explains to them how they can return the declaration to the landlord if they want to claim COVID, that they've been affected by COVID, and that's the reason why they can't pay the rent. And you're serving them with the 15-day notice with that declaration. And then after you do that, your resident in your mobile home park has 15 days, skipping Saturdays and Sundays and court holidays. When you count the 15 days, you skip over the Saturdays, Sundays, and holidays. And then within that 15 days, that resident needs to come down and submit the declaration if they're claiming COVID. If they don't sign that declaration within 15 days, then yes, you can get with your lawyer about going forward with the unlawful detainer complaint once your 60-day notice, because remember, you're serving your 15-day notice to pay rent or quit, maybe your 15-day notice to perform covenants to cover the utilities, and your 60-day notice to terminate their tenancy. So serving them with the 15-15-60 plus the COVID declaration. If they don't return the COVID declaration to you within 15 days, then you wait out the 60 days, and then after the 60 days expires, then your attorney can tell you if it's okay then to file the unlawful detainer with the courthouse. Many lawyers have also, no doubt by now, been advising you that that sounds straightforward, but this COVID law, like the last COVID law, also says that once you get to the unlawful detainer proceedings, or you file your unlawful detainer eviction court case with the courthouse, there's a provision in the law that says that even when you're as late as being in the court proceeding, the resident can make a motion to the judge and tell the judge that due to inadvertent mistake or neglect, or they just forgot, they forgot to return the declaration to the landlord within 15 days. And they can ask the court for permission to now file and serve the COVID declaration right there in the court proceedings and prevent the court proceedings from going forward. So that's something we should keep in mind too. But anyway, just like the old law, there's really what the law says is there's really two things that the tenant needs to do when the tenant claims COVID and is preventing you, the landlord, from evicting them. There's two things that that tenant needs to do to not be evicted. One is to give you the declaration within 15 days. And then like last time, the law says now it pushed out the date. It used to be January 31st. Now they pushed out that date to June 30th. The second thing that that resident must do is that the resident must pay you 25% of the total amount of rent that they owe by June 30th. So if they give you the if you serve someone with a 1560, let's say today, and within 15 days of today, they give you the declaration, and by June 30th, they pay you the 25% of rent that they owe for the whole period of time since they've been defaulting, then you, the landlord, cannot file an eviction. You cannot evict this person. At the same time, what the law says again this time, like it said last time, is that the legislature is not forgiving rent. So, like last time, they're saying that the landlord who is still owed 75% of the rent as of June 30th may seek to recover that 75% of rent in small claims or in another limited civil proceeding lawsuit maybe brought by your attorney. So that's, you're very familiar with that. Same thing, last time they said you couldn't file a small claims until March 1. I believe they've, I have another slide here that they've continued that date that you can't sue in small claims until I think August 1. So moving down the dates, but the same principle. Like the last law, this law also repeats this provision that says that today, next month in March, in April, in May, every single month, the landlord may require that the resident sign a new COVID declaration. I'm not quite sure why they're saying you can do this, and I'm not quite sure at this point why you should. Because let's say today you serve the 1560 and the COVID declaration today on, February 19th. And let's say, 10 days from now on February 30th or February 28th, that they give you the declaration. Well, if they gave you the declaration today on February 28th, then there's nothing you can do, and you wait till June 30th to see if they pay you the 25% rent. So if that's the situation, I'm not sure why you would take the time and effort to ask them in March and April and May to sign a new declaration. I guess it's asking them to verify again that they have a COVID problem. And I suppose you could take the position that if I serve them with a new declaration in March and they don't return it within 15 days, can I evict them? But you see the problem. I think most lawyers are going to say, no, I don't think a judge is going to go for that. I think the judge is going to say, as long as they returned the first declaration in February and pay you 25% of rent owed on June 30th, you can't evict them. Of course, I realize that a lot of our MHET members own very large and small, but whether it's a small or large park community, let's face it, there's a lot of, that would take a lot of logistics and a lot of probably brain damage to, go around and do new declarations every single month. And, for the headache, I'm not really sure we're going to get anything out of it to go around and ask that they sign a new declaration. But, that is still on the books. As I said before, a big change was last year, we didn't have the special rental assistance program. So this year, it's sort of, they copied the old COVID law. They changed the dates, but they did add a lot of provisions now where they have this rental assistance program in place. So that means that your 15-day notice must advise the tenant that he or she may qualify for the rental assistance. I think this is the quote that is in the law that I think you're supposed to put in the 15-day notice. So you can see what the tenant is being told. I think it says, these words: California, in partnership with federal and local governments, has created an emergency rental assistance program for people who have been unable to pay their rent. The law does specifically say in the statute that tenants may apply for the assistance regardless of citizenship or immigration status. And the notice also refers the tenant to a website and a phone number for more information. Again, this is a huge amount of text here, and please don't let it give you too much of a headache. I think the takeaway here on the rental assistance program is that it's funded with about $1.5 billion or so. I think the other takeaway is that they're not prepared to accept applications until March 15th. So keep that in your head when you're thinking about this. And then finally, this is the main takeaway, is that what the government is trying to do is it's trying to encourage landlords and tenants to apply for this assistance. And so they want the landlord and the tenant to apply and see if that tenant qualifies. And then they want the landlord, what they want to do is have the rental assistance pay the landlord back 80% of the past due rent that's owed from April 1 to March 31st, I have here on my screen. In exchange, the government wants the landlord to completely waive and forego forever collecting the 20%. So you apply to the government for rental assistance, you get rental assistance, and the government is going to say, okay, how much rent is owed? And you say, $1,000, and the government gives you $800, and we all anticipate, we'll have you sign a release saying that you waive forever the 20%. So you're waiving that 20% forever. You cannot later on in August go into small claims and say, hey, I want that 20% that I didn't get when I accepted 80% of the back due rent with the rental assistance program. So I think where most people are on this is later on, I'm going to talk to you in this presentation about how judges have the discretion to reduce your damages in court if the judge finds that you, the landlord, didn't make a good effort or any effort to apply for the rental assistance. So I think that if you've got this situation, you and your attorney should seriously consider going through the work of applying for this rental assistance and decide if this is what you want to do as a park owner landlord, accepting 80% and waiving the additional 20%. So someone had a question about utilities, and in my last bullet point there, utility arrearages will also be eligible to be paid. So the reason why the Met and Vicki Talley and Eileen Cirillo have worked so hard behind the scenes, and they really have worked really hard behind the scenes to put this program together for you and get the information to you today on February 19th, is because there's a deadline that's coming up that the Met wants you to be aware of. And that is that just like last time, in the new law, the law is requiring that landlords serve an extra notice. It's a one-time only notice, but nonetheless, it's a notice that used to be served by February 28th. I think around our office now, and the way the statute's worded, we call it the February informational notice. It needs to be served on any resident who owes you rent as of February 1. So if you are owed rent for February or before February, if you're owed rent for December or January or February, or a combination thereof, you need to serve the February notice to them on or before February 28th. Is there anything particularly different, Dan, about the February notice? I mean, you just got done saying that I have to put all this notice stuff in my 15-day notice. It's really not. I just looked at it again this morning. I looked at the 15-day notice, and then I looked at the February informational notice. They both explain the same thing to the tenant, that you can return the declaration, that you can pay 25% of the rent by June 30th, that that there's a rental assistance program, that you can find out more information about the rental assistance program if you go to this website or call this phone number. For whatever reason, that's what the legislature did. They decided that when the law starts on February 1, we not only want to change what you have to say in the 15-day notice, but we want you, anyone who owes you rent in February or before February, we want you to serve this extra notice by February 28th. One of my clients had a question, do I have to serve this February notice to everyone in the park? And the answer is no. You're serving the February notice to everyone in the park, or only those people in the park that owe you rent. So if they don't owe you any rent, you don't have to serve them with a February notice. If you have a resident who's current on the rent all the way up to today, February 19th, they owe you no money, no problem. What happens if next month on March 6th, they default on the rent? Do I have to serve the February notice? I would say no, because this is you see the law right in front of you. It says if you're owed rent on February 1, you have to do this act of serving the notice by February 28th. So it's just a one-time notice that you have to get done this month, but you're not going to be serving the February notice if the first rent default occurs next month in March. And I say in the second bullet point, we had the same issue with it was called a September notice. Last time we had to serve this notice by September 30th. Now we're at February, and we want to be sure at the Met to get you this information, because this is one of the deadlines you don't want to miss. You may have another question. You may be asking yourself, well, do I have to serve this notice if I intend to do a rule violation eviction that has nothing to do with rent? That's a really good question. I think the answer is, talk with your lawyer. But I think my short answer is, if today on February 19th, they do not owe you any rent, but they're violating park rules, no, you don't serve them with the February notice. But what if they really are violating a lot of park rules today on February 19th, and they actually do owe me rent? And I don't really think I'm going to evict them for non-payment of rent, but I think, Dan, I am going to evict them for rule violations. Should I serve this notice? And I've had 2 associates come into my office this week with that precise question. And I think we're leaning on the, we're erring on the side of caution. And we're saying, you know, we don't want to be hooked. We don't want to be any problems with the judge later on in court. So even though we plan on doing a rule violation eviction, when we get to our trial on our rule violation eviction, I don't want a judge taking the bench and saying and asking my park manager, well, did they also, separate and apart from the rule violation, did this tenant owe you rent on February 1? And the park manager says yes. And then the judge says, well, did you serve the February notice? And the park manager will be looking blank and looking at the lawyer and saying, should we have served the February notice? So get with your lawyer. And if you are thinking about evicting someone for any reason under the mobile home residency law, get with your lawyer about what your plan is and whether or not you think it would be safer and a better idea to serve this informational notice, or if you think that the likelihood is that the judge won't penalize you for not having served it. This is a little bit into the next step, which I talked to you about, which is if later on you're going to file an unlawful detainer action, and now what the law is, one part of the law is saying is that when you file that unlawful detainer complaint with the courthouse and you're seeking unpaid COVID debt, the law requires you, the landlord, as the plaintiff in the lawsuit, to attach to your complaint documentation showing how you, the landlord, made a good faith effort to try to get some of that rental assistance money. And so I'm not going to read this, but you know, I gave you sort of the text and sort of what the law looks like. You know, the judge wants to see documentation as to how the landlord made a good faith effort to investigate whether there was rental assistance available and so forth and so on. So if the judge finds that you didn't make an effort to go get the rental assistance and get yourself paid the 80% and waive the other 20%, then this is the code section at the top that says that the statute says the court has essentially the discretion to reduce the damages awarded for any rental debt if the judge finds that the landlord refused to obtain rental assistance. But that, of course, assumes the tenant met the eligibility requirements and the funding was available. You know, this is going to have to be worked through, because what if the funding runs out? You know, then how equitable is it going to be if we all know the funding ran out and the judge is going to penalize us for not trying? So again, this is, whether you call it the carrot or the stick, I suppose this is the stick, where the government is trying to put in the law some penalties potentially down the road if you don't try at least to go get that funding that they now have ready or will have ready starting on March 15th. If you're really trying to seek recovery of the rental debt, there's some limitations on when you can file the action. I think it's not before July 1. And I'm trying to put down some other things here. I know there's like, I think the takeaway on these other bullet points is that if you and your lawyer should sit down and say, do we want to be caught up in all of this, you know, court discretion and applying for the rental assistance? Some clients will tell me that they only want to go to court and seek possession. And the law does say, well, if you're willing, landlord, to go into court and only seek a judgment for possession that you want back possession of the premises, then all of this stuff we're talking about here on this on this PowerPoint screen does not apply. So you might want to get with your lawyer and say, look, do I want to make this more streamlined in the court system and only seek possession and waive my monetary damages? And that's something you and your lawyer can decide. I wanted to point out, and I hope this doesn't get too far into the weeds, that oftentimes a landlord can seek holdover damages. That is damages that are from the point of when the 60-day notice expires to the day of trial. And a client may think that they want to waive those holdover damages and just go for possession. I think that's fine, but a good discussion needs to be made that we don't know nowadays with COVID when you're going to get that trial date in the court system. You know, prior to COVID, we were pretty confident that we could get you a trial date within about 25 days. But now what COVID has done is it's hit our court system very hard. We're finding that they're understaffed in terms of clerks, and the court system is not being able to give you a trial date as early as it used to be in the olden days before COVID hit. And so my point of it is you may not want to give up certain damages like holdover damages, because what if you don't have a trial date for several months? And I know that's not what everyone wants to hear. We want to have an expedited process, and we try to get a trial date as soon as possible. But I'm just letting you know that the court system itself is not working the way it's not working the way we typically want it to work or think it's going to work. So it's been a lot of fun lately trying to predict how soon and how fast these cases can get through the court system. This is just a slide again on the small claims. Again, you guys recall that the old law said that if your tenant paid 25% of the rent, you could then go and try to get that 75% in small claims. And the law said that you had to wait until March 1 to file your small claims. They've kind of jumped over you now, and with the passage of this new law, they're pushing your date back a little bit, saying that you can't commence or start your small claims now until August 1. And I think that that's probably a compromise. I'm not a legislator, I'm not even a lobbyist, but I think we all know from reading the newspaper and keeping track of what's going on in Sacramento, that I think that, you know, they're telling landlords now, we've moved down the date when you can go into small claims. I think they're doing that because they really want everyone to, you know, try to apply for this rental assistance before the landlord resorts to suing someone in small claims. So I think that's, as you can tell, this is the whole theme here, you know. I think when you park owners, the whole idea of small claims is that the landlord does it by himself or herself in front of the judge, and you're not allowed to have a lawyer represent you in small claims. And I think that when a lawyer does represent you in another type of civil proceeding, there's that law I discussed about giving documentation and showing the judge what efforts you made to apply for the assistance. I think one of the issues that we're spotting as lawyers is, what should we tell our clients when our clients go to small claims court by themselves? Should that client also attach documentation? Do they need to attach documentation showing that small claims court judge what efforts we made to apply for the rental assistance? So that's getting a little bit into the weeds, but just in terms of being full service to our clients, make sure you get with your attorney and make sure that your attorney can assist you in helping you prepare for your small claims. The attorney just can't go with you. Probably the attorney could sit in the audience maybe, but they really can't represent you on the day of the trial. So, or the day of your hearing in front of the judge. But you can get with your attorney and have your attorney help you prepare. And I say finally, the kicker, I think we're doing pretty good. I just have a few more slides, and I think we're doing good at 11:46, 11:47. I say finally the kicker because they've added this provision, 1179.03.5. And the best way of explaining this to you is the law is saying that there's these hurdles that you have to follow in order to evict someone for non-payment of rent. And, you know, we've talked about that. There's a hurdle that you need to show the judge you served the February notice. There's a hurdle that you have to serve them with the 15-day notice and the COVID declaration. And you have to do all these things. This code section sort of is a last hurdle. And that last hurdle is that the way they've worded it is they've said that before July 1, a court may not find a tenant guilty of an unlawful detainer, and that appears to be any unlawful detainer, whether it be landlord, mobile home, RV. A court may not find a tenant guilty of an unlawful detainer unless the judge finds one of the following. Now, in most cases, this code section would not be a hiccup because as you can see, the judge just needs to sign off that this was an at-fault just cause or a no-fault just cause. So for instance, if you were trying to evict someone in a mobile home park for substantial annoyance or rule violation, those would most likely fall under at-fault just cause, no problem. But like I said at the beginning of this program, we are having some attorneys, some opposing counsel make arguments that if your client, if the park owner evicted someone with a notice that was without cause, because sometimes there are notices that you can just give them 30 days or 60-day notice, but you can do it without saying cause. It could just be no cause. I'm terminating your tenancy and you need to vacate in the next 30 days, 60 days, no cause is stated. We have two legal aid society, two different law firms that are making pretrial motions to us now saying that under this kicker, I'll call it the kicker, your unlawful detainer can't go forward. Why? Because when you evict someone for no cause, that doesn't fit into one of these bullet points. And for the judge to find the defendant, the tenant, guilty of an unlawful detainer, the judge has to fit the eviction into one of these bullet points. And our eviction, so the argument goes, of evicting someone without cause does not fit into one of these bullet points. So I'm just raising and pointing out these issues that your lawyer and your lawyer and our office deal with every day. There's a lot of arguments that, you know, that's ridiculous, Your Honor. There's some arguments to be made that a tenant is only going to be found guilty at the trial. And I think we're almost laughing at our office that we probably won't even get a trial date until July 1, when this statute isn't even applicable. But what we are finding with some of our clients is that this statute is important because we do have some tenant law firms that are filing some motions with the judge right now to prevent us from going forward with the eviction. Separate and apart from what we've been talking about, today we've been talking about state law. We've been talking about the Sacramento, California Tenant Relief Act and the program to get funding through the California program. Separate and apart from the COVID moratorium laws that say give a 15-day notice, give a declaration, set that aside. And what you also have is the federal CDC eviction moratorium, which I believe was continued. I think it was continued to March 31st. I know it was December 31st, but I think it's been continued. So most of the lawyers that I know in our industry have put on some other webinars, and they have said that in terms of the MRL, mobile home residency law, non-payment of rent, evictions, or all MRL evictions, the lawyers have said that this CDC eviction moratorium does not apply. And the reason for that is because the CDC eviction moratorium says right there in the order that this order shall not apply if you're in a state like California that has greater level of public health protection than what the CDC provides. And the CDC simply says that tenants can get a declaration and bring it into the park office. I think most lawyers feel like California does provide greater protection because California law requires that the landlord provide that declaration to the tenant. So we feel pretty confident that this CDC eviction moratorium doesn't really apply to the mobile home residency law evictions. If you're doing another type of eviction, like one brought under the RV code, you'll want to get with your lawyer because the new state law didn't really address or even mention the RV code. So now there's a legal issue as to whether or not the CDC eviction moratorium applies or doesn't apply to your RV evictions. This is a lot of text. I'm not going to go through each bullet point. The reason why I wanted to write this out is because I just wanted to recite what the CDC order says. It says that you can't evict someone if they give you a declaration that says all of the following. We have these 1, 2, 3, 4, 5 bullet points. My point in doing this is I think that if you ever get a CDC declaration from your tenant, you probably should go over that declaration or give that declaration to your attorney, because your attorney will want to look at it and first of all, check the boxes and make sure that the declaration that the tenant got randomly off the internet is in fact has all the requisite language that the CDC order requires. That is, the lawyer is going to want to look at the declaration that the tenant gave us and see if it actually contains everything in the declaration that the CDC order said that it must contain. Also, I just wanted to briefly, now that we're at 11:55, we're doing good on time. That'll give us about 30 minutes or so on questions. I did want to mention too, to be kind of comprehensive today, that that Cal OSHA has updated some regulations regarding an employer's requirements to create a written COVID prevention plan, and some of the requirements on employers for paying for employee testing and keeping track of sick employees. And you can look at that yourself and look at that with your lawyer. And then of course, I think they also say it's not applicable if you only have one worker or you have all your workers working from home. In this day and age of COVID, I know that a lot of our park communities have a park manager in the park office, perhaps with the door shut, with servicing our residents through the door with a doorbell, or putting rent checks or lease agreements through the door slot on the front door or under the door, whatever it is. So you may find that you have enough to worry about right now. You might have one employee working by himself or herself in the park office, and you might find that this is not really applicable to you, but I think that we thought it was important to just remind you of this in case you want to be not get tripped up and want to be compliant with it. So thank you very much. I know I threw a lot of information at you. I hope it was helpful. And Vicki, do you want to see in a little Q&A if we have some questions?
Yes, we have several questions. One thing that I want to touch on a little bit, though, is we talked a lot about evictions and a little bit about the rent subsidy and applying for that. It's very, very important that the park owners work with their residents to make application for the subsidies. And those will actually come through your county, or if your park is in a jurisdiction with over 200,000 or more residents population, they will administer their own program. I'm finding that most of these actually are, the city of Santa Ana, as an example, is going to the state. They're putting these all together. We're monitoring very closely in our Tri-County region, in Orange, Riverside, and San Bernardino counties, and the large cities in those counties. We're monitoring closely, and we'll get that information out as quickly as it's available. But I encourage you to also monitor the websites on how applications are done. Encourage you to coordinate with your residents who are late on their rent, to encourage them to apply, and you apply together. They will need they will need their rental agreements and so on. So it's, and I also want to make sure we encourage everyone to be on top of this and apply as quickly as possible, because there is a finite amount of funding. I think that Dan made it pretty clear that if you went into court trying to evict someone for non-payment and you did not avail yourself of the 80% rent subsidy, that's not going to be favorably viewed by the judge. I'm sure there may be other questions, but let's ask we've got some other questions that I'd like to go ahead and address to Dan. Dan, could you clarify if a resident only has the current February 2021 delinquent rent, is that included for determination which resident should be given the information notice before 2/28? I think they don't, but can you make sure we have that clarified if they're delinquent on their current February rent?
Sure. If you have one resident who today is delinquent on their February rent, you need to give that one resident the February notice by February 28th. If you have other people in the park who, as of, let's say today, February 19th, have not owed you any rent, don't owe you any rent, then you do not need to serve the informational notice on them. It's just for people, let's say, as of today, to keep it simple, people today that owe you rent, you need to serve them, only those people, with the February informational notice by February 28th.
Okay, one other on that, do you serve the February notice if you're doing a forcible detainer? I'm not sure I understand the question, but perhaps you do, Dan.
Sure. The word unlawful detainer and forcible detainer, they mean two different things. An unlawful detainer is something is an eviction process you do when you're trying to evict a tenant who has a tenancy in your park. Forcible detainer is our terminology for an eviction proceeding when you're trying to remove a squatter, or perhaps a caregiver, or a companion, or a guest, or anyone else in the park who does not have a tenancy. So with forcible detainers, the person does not have a tenancy and the person does not owe you rent. So if you're doing a forcible detainer, it does not involve the tenant. It does not involve the tenant not paying you rent. So the answer is, for a forcible detainer, no, you would not, essentially, you don't have to serve the February notice on a squatter in a mobile home.
Good. Okay. Real quick, why do you say 15/15/60 and not just 15/60?
Sure. And that's a great question. Some of the forms, maybe from MHET or from WMA, their forms say 15/60. And what it is we are talking about like three different notices. We're talking about a 15-day notice to pay rent or quit, a 15-day notice to perform covenants, which covers your utilities, and then a 60-day notice terminating their tenancy. We call it 15/15/60 because at my office, we draft the three separate agreements. When you go on to WMA's website, I think they do a 1560, which is they do like a 15-day notice to pay rent or quit with their 60-day notice. I think they might have a separate 1560 for covenants, and they simply repeat the 60-day notice. So we're talking about the same thing, but that's the reason why I say 1515, and yet you might be very familiar with just calling it a 1560-day notice.
Okay, this one, I remember listening to the Apartment Association webinar on this, and so it's on how you apply the rent. A state landlord association claims that rent collected can only be applied prospectively unless the tenant has stated in writing otherwise. So they would have to agree to allow you to apply the rent before. Hypothetically, for transition period, if the tenant owes $500 for February and pays nothing, and then in March also owes $500 and pays $300, as a landlord, do you credit the payment to February or March? Is it understood that the obligations due through August 30th are still protected?
I believe I believe you can credit the extra $100 or $200 in March to the February. I don't see that being a big issue. The way the questions asked about how you credit it. The point of it is if they owed you rent in February, you need to do the February notice. But then if they also, and you did nothing, you just served the February notice, that's fine. And then they also don't pay the rent in March, then say on March 15th, you can do your 1560, saying the unpaid rent that they owe you to date for February and March. So if someone knows the answer and they want to correct me or send me an email or something, but I'm not aware under the mobile home residency law that we have to credit it to March or February. What is important in our daily life here at our law firm is that the 3-day notice or now 15-day notice, the 15-day notice to pay rent or quit, you may not overstate the amount of rent that's owed. And so we all know that, I think, but we know that if we overstate the amount of rent that's owed in our eviction notice, we can have the whole case thrown out in court. So,
should the February notice be provided to residents at short paid, $10 or under, still due? Wow, but may not be served a 1560.
If someone owed you, say, $500 rent by February 6th, and they're $10 short on the rent, they're short. They've defaulted on the rent. So, I mean, in theory, you could evict them for not paying the full amount of rent, and you could serve them today with a 1560. And yes, you need to serve them with a February informational notice. Now, if it really is $10 short, I understand every dollar is important, and you don't want the resident to believe that they can get away with paying $10 short every month. I get the back and forth issues, but $10 short is not that much money to pay a lawyer to go through all the eviction. So property managers, I think, will get with that resident, find out what the problem is, perhaps give them a warning and let them pay the $10 today or tomorrow and come current, and then just try to monitor that next month and the month after that. So my answer is more of a practical thing, but technically I think that if you're talking about a partial rent payment, no matter what that partial rent payment is, that's a default, and technically you'd owe you'd have to do these requisite notices.
Okay, another question. The new 15-15-60 is for the period 9/1/2020 through 6/30/2021. If the resident's delinquency started prior to 9/1/2020, would more than one 1550-60 need to be served, or is it covered by the previously served notices? Say if the resident is making partial payments, the total due would not be accurately noted on the new notice.
The answer is that, you know, I think that if you sit down and discuss it with your attorney, I think you might be in a position where you try it, but if they owed you rent prior to September 1, remember you were required to serve the September informational notice by September 30th. So a lot of complicated moving parts, but I mean, if I was your lawyer, I'd probably say, sure, let's try it. But I would caution my client that, you know, I would ask my client, did you give them the September informational notice? And if the answer is no, I forgot to give them the September informational notice, then I think we should just be on the same page in terms of a judge may, you know, at the end of the day in court, not allow you to recover back rent prior to September 1 because you didn't do the September declaration.
I think this is the same question because the law has now changed. Do we need to serve the new 1550-60 to residents who've already been served one? Or is that a different?
You know, I think that the answer is yes. And the answer is yes because just like last time, what the new law said was it said, okay, starting on February 1, 3 weeks ago, starting on February 1, 2021, anytime you're seeking COVID rental debt, your 15-day notice has to say the following. Okay, and your position is, well, Dan, I served this 15-15-60 last month in January under the old law. Well, the new law says it doesn't matter when you served your notice. And what the law is saying is it doesn't matter. If you served a notice previously last month or in December, and at that time you had the notice correct, it's saying as of February 1, you got to have an eviction notice that's served that has this magic language, the new magic language, in order to evict someone. So, you know, I haven't looked at your documents. I haven't looked at your, again, try not to rely too much on this question and answer, just in the sense that I haven't looked at your file. I don't know what kind of tenancy it is. I don't know what kind of rental agreement it is. I haven't looked at your 15-15-60. But my answer is I think you probably should have that reviewed with your attorney because I'm thinking that the answer is no, it's not good enough. And yes, you need to reserve a new 15-15-60.
This is interesting. So a resident looks to be not happy with a pass-through. So if the resident has refused to pay a pass-through and has a balance forward for the amount as of February 1st, 2021, do they need to be served the notice?
I think so, because like we said, it talks about rental debt being owed, and it defines rental debt as the rent and any other financial obligations owed to the park. So if you're saying, well, there's this, you know, pass-through. Okay, well, the pass-through is going to be considered by the judge to be a financial obligation, which it is. It's their financial obligation to pay you the pass-through. So if they have defaulted on a pass-through, I would say, yes, you need to get that February notice served on them before the end of this month.
Okay, would you caution that the timing for a rules violation eviction where the tenant also owes rent should not appear to be avoiding the non-payment eviction by belatedly raising rule violations? I think that you did address that, but you want to?
Yeah, no, it's a really good question. It's a really good question because there are statutory penalties in the new COVID law for anyone that kind of appears to be or found guilty of trying to circumvent the 15-day notice, the COVID declaration. And, you know, the law wants to punish people that are doing an end run around the COVID law. And so we want to be very careful because what if you have a situation where they owe you rent, but they also are violating your park rules, and you want to do a park rule violation eviction? Are you going to get in trouble? Is the judge going to consider you doing an end run around the COVID laws? That's a tricky thing. I mean, I think myself and other lawyers feel like, no, this is the law. If you're going to proceed on non-payment of rent, you have to comply with the COVID law. This is not a non-payment of rent. This landlord is elected to evict on different grounds, which is a rule violation, and the COVID law doesn't apply. No problem, these are my options. And the fact that the landlord elected to go with a rule violation eviction, I shouldn't get in trouble. That's, I think, the way we're going to come out 80 or 90% of the time. If I see a fact pattern, though, where, you know, they paid an insufficient amount of rent, and we gave back the partial rent payment, and then the very next day we did a rule violation. I mean, I could sort of imagine in my mind a fact pattern where I would look at it and go, oh, this kind of starting not to look good. This is sort of starting to look like a timeline, a fact pattern where we are, you know, it may appear like we're circumventing the COVID law. So I think it's a really good question. I think the takeaway is we should all be careful that it does not look like we're circumventing the law. On the other hand, we have every right to do a rule violation eviction.
Okay, do legal owners still need to be served a copy of the 1560 within 10 days of a service on the homeowner, even though the homeowner has 15 days to pay from the date of service?
Yeah, the laws look, yes, the answer is yes. They haven't changed. The MRL under 798.56 tells you all those things you have to do with the legal owner. And then the COVID law comes along and adds and changes it from a 3-day notice to a 15-day notice. But the other provisions in the MRL saying that you have to give a copy to the legal owner within 10 days and all that, that remains in place. That wasn't affected. So you still have to do everything else you normally would do under the MRL.
Just to clarify, if the resident does not return the COVID declaration within 15 days or pay, you may move forward with a UD action at the expiration of the 60-day notice if you waive the rental debt, but you cannot file before July 1st, 2021. If you want to collect that rental debt, what happens if the resident files a declaration in court where you say the complaint you are waiving, where you say in the complaint that you are waiving all damages?
Yeah, I know. I think that's a good question. I mean, the point, the lawyers are focused on the fact that when you're in court, if the tenant, I'm trying to, maybe I want to make sure I answer the question. What you said in your question, I followed, and I think it's a perfect statement of, I agree with you. And I would say, you know, if you want to file before July 1, don't seek recovery of COVID debt. But if your question is what happens in the middle of court where they make a motion to say, I want to file my COVID declaration now, I believe the statute says, you know, then the unlawful detainer can't go forward. And I have to analyze in that particular case, what exactly would be the result then? I mean, does the resident get to stay in there forever? When do they owe you the 25% rent? You know, I suppose the unlawful detainer is dismissed if the judge allows the tenant to submit the declaration in court. And then having submitted the declaration, then you go back to the mobile home park and they go back to the mobile home park and you wait until June 30th to see if they pay the 25% rent.
And I'm still getting a couple questions on where they apply for the rental assistance on March 15th. And again, those jurisdictions, the counties and the cities are still formulating their programs. And as soon as they get those done, I do know the city of Santa Ana will be going through the state of California, and that'll all be on their websites. They'll be launching that information. As soon as they do, we'll get it out to everybody, but they're all in the process of making sure they get those announcements on their website. So it's, again, you need to check with your county or city, large city of 200,000 or more.
Yeah, and then the COVID law here, the statute, the website they say is housingiskey.com. Housingiskey.com is the website. So I don't think they're accepting applications on this until March 15th. But if you want to go onto that website to prepare and get your application ready, then you can go on that website and start learning about the how to apply for that rental assistance.
And do any notices have to be given after the February 28th notice? In other words, if somebody's delinquent on rent in March and April?
No, they don't require, the February notice is if they owed you rent in February, as of February 1, you serve it by February 28th. There's no provision that you have to do a similar one by March 28th and a similar one by April 28th. Basically, what we're saying is if they owe you rent as of February 1, serve the February notice. And then if you want to, you could try to work it out with the resident. And then you can see if they default on March 1 or April 1. Whenever you want to pull the trigger, then you could do your 15, 60-day notice at that time. But you want to make sure that you had served them with at least the February notice by February 28th.
This is again on the eviction for other than non-payment of rent. What if the rule violation eviction were where the tenant also owes rent, involves the expenditure of money? In other words, they have to repair, paint, landscape, and all of that. Is that going to make a difference if you're waiving the rent?
I don't think so. You know, I know it's kind of confusing. We're talking about rent and utilities and financial obligations owed to the park. Then separate from that, we're talking about evicting someone for a rule violation that said something like your awning over your carport is all bent and you need to fix that awning within 7 days. And they're having to open up their wallet to spend their own money to fix the awning. Is that going to be a problem under the COVID law? The answer is probably not. It shouldn't be a problem. You're allowed to go forward with your rule violations, and if that rule violation required them to spend money and they couldn't afford it, I guess that's the real question, and it's a good question, which is, I'll state the question back to our member, which is, well, what if someone comes into the park office and says, due to COVID, I don't have the money to fix that awning over the carport and cure my rule violation, the rule being that you have to maintain your awning in good condition all the time. That's a question. I think that legally you would be able to do your rule violation, notwithstanding the tenant's argument in court that due to COVID, they didn't have the money to fix the awning. That's, you know, there's a legal grounds for connecting the dot and going through the whole court system. But I would be counseling my client that let's see if we can do something else. Because, you know, we're really making these technical arguments why we're right. And I would hesitate perhaps to go in front of a judge who might be, you know, very cognizant of COVID and not wanting to create homelessness, and we may not get the best judge in our particular case. So while we have a perfect legal case, I want to get with my client and discuss, you know, what can we do? Can we have them repair the awning over time? What's his situation with COVID? Does he think he'll get his job back? You know, has he gotten the vaccine in his arm? You know, what are the circumstances?
Does the February notice need to be served prior to serving a 15-15-60, or can it be served in conjunction? Does it require its own proof of service?
Good question. The statute expressly says that you may file it concurrently. And in terms of does it require its own proof of service, it can be served concurrently, which means that, you know, it can all be stapled together and you can sign one proof of service, but at the top of the proof of service, where you're saying what document you served, you want to make sure on your one proof of service that you say at the top that I served a 1560-day notice and the February informational notice, and then serve it and sign your name under penalty of perjury on the proof of service. A judge just wants to see that there's a proof of service on file where the park manager is saying under penalty of perjury that he or she did serve the 1560 along with the informational notice, and one proof of service is fine.
On the same line, since you can't go to court until July, should we just keep serving a new 1560 each month, assuming still a debt is due through May?
Well, you don't want to do that, because what we're talking about is a 1560-day notice, meaning if you serve the 1560, say today, your 60 days is not going to expire till March, April, and then between the date it expires, when the 60-day notice expires on April 19th, 2021, there is no like statute of limitations between that time and July 1, meaning that time can go by and then on July 1, you can file your UD. If you turned around and served another 1560 on at the end of July, then it'd be May, June, and it's not required. You don't have to. And it's probably just cumbersome to do that, to reserve another 1560. And also, you want rental debt and holdover damages, and you might be hurting yourself in obtaining holdover damages if you serve a second 1560-day notice.
Very helpful. If a tenant is in default for all months of the transition period through December, and 1560 notices were served for those months, and tenant declarations submitted by tenant for all months, then January, all transition months were included in the 1560 with January added. But this time the tenant did not return the declaration. Would the declarations from the previous months still protect the tenant and prevent going forward?
The answer is yes. I believe the first declaration is going to protect them through the process. But the more concern I have is when, from your question, let's be very careful if you've got non-payment of rent during the old time period up to January 31st, and you're letting that still exist today in February, and you may want to evict them in February or March of this year. Again, I think in that case, a new 1560-day notice needs to be served. So I really need to look at the documents, but to answer your question, but there's just two principles here. One principle is that generally speaking, they only have to give you the declaration once. The other principle is, though, that with the new law, I believe the new law is saying that if you had an old 15-day notice, you have to redo that 15-day notice today in February, to have the new language and the new 15-day notice about the rental assistance program.
I think that we've about covered all the questions, and that's pretty good timing, I think, actually.
We did really well.
Yeah.
Well, thank you, Vicki, so much. I hope everyone found it very useful.
Oh, it was excellent. And that will be going out with a survey to our members, inquiring about how many rent deferments you have and so on. I think it's going to be critically important to have that information when we're asked about it. But I want to encourage everyone to participate in this subsidy program. I think the view is going to be that you had the opportunity to regain some of those rents, and it'll be a good thing if you work on it. So thank you all for participating and have a great day. We'll look forward to seeing you next month. Take care.